to you. Jason Korta is HAR's staff attorney. He is a graduate of Northeastern University School of Law and participating attorney with nearly a decade of experience in real estate litigation and transactions. Jason began his career in Boston and New York. He later moved to Honolulu, where he served as session attorney to the House Judiciary Committee, and then as associate attorney for a large real estate litigation firm in downtown Honolulu. Let's help me to join me in welcoming Jason Korta.
Hi, thank you for that kind introduction. I have a presentation to share with you. Let me begin sharing my screen so that I can do that. There we go. All right, I'm gonna move this bar out of the way. There we go. Perfect. All right, so there are two major topic areas for today's presentation. One, the upcoming biennial release of forms, in which there are 8 new or substantively revised forms, and then recent hot topics in legal Kokua. So to the first topic, new and revised forms. As I mentioned, there are 8. They are the agreement of sale addendum, backup offer addendum, blank addendum, blank amendment, designated agency disclosure and agreement, plain language addendum, and the rental agreement. I'll give a very quick overview of the changes to those forms. Excuse me. The agreement of sale addendum, you'll see the annotated version here. So the annotations show the changes made over the current version of the form, the one that you can download now on our website. There were numerous, mostly non-substantive changes that the Standard Forms Committee made to this form to add clarity and style. Mostly those changes help people understand the use of the form. We understood that some people were using this form as an amendment to the purchase contract, which it is not for. It's meant as what it says it is, a simple agreement of sale addendum. So we added language there to make that clear, but there were no real substantive changes. And here is a clean version of that form now. We had that backup offer addendum. This form is a new form. It was created because multiple offers are becoming more and more common, especially in the current bull market. So we created this form to allow sellers and their brokers to accept more than one offer on a property. The form's useful in the event that an offer on a property falls through. You have a backup set up already. So this will be released with all the other forms listed here on the left during our regular biennial release of forms on November 1st this year. We also made changes to the blank addendum. New language was added at the top. Again, apparently some people were using this form as a amendment to the purchase contract, and that's not what the form can be used for. So we added language at the top to clarify the form is not for use as an amendment to an existing contract, and to direct those who would like to amend an existing purchase contract to use the blank amendment, which we're about to discuss now. But before we do, that's just a clean copy of the blank addendum. All right, so the blank amendment. That was revised. So I gotta check my notes. Oh, to conform to similar sections in similar forms. We noticed there was some unintended conflicts between this form and some other forms. So we revised language to make sure that there was internal consistency among all our forms in our library. There were also other miscellaneous non-substantive changes. And that's a clean copy of the form right there. Then we moved on to the designated agency disclosure and agreement form. This is a brand new form and one that's generated a significant amount of discussion. We've had, I believe, 4 workshops, 1 webinar, and we have 1 more webinar to come on the topic. There is great interest in it, and it's a bit of a complicated topic, so we've devoted as much time as possible to discuss it. And if you have any questions we'd like to discuss it here, I'd be happy to take those questions at the end of the presentation. But here on the right, you can see there's a clean version of the form that will be released on November 1st. And plain language addendum. There were various technical and non-substantive changes made to this form. Also, the reservations provision was changed to make it more understandable. The prior language had been kind of maybe unnecessarily complicated. The plain language addendum and clean copy, the one that you'll be able to download in November, is available there for you to see on the right. Okay, and the final form, the form I'm going to discuss in the most detail here, is the rental agreement. You may remember that the rental agreement has been revised frequently. The most recent revision of it was in May. That was to conform to a law change, HB 1376. It's being released again as part of the regular biannual release of forms with, again, new substantive and significant changes for a variety of reasons, of which I can discuss with you now. I won't hit on all of them. I'll just try to hit on the larger points. So the main thrust of the changes for this form is, again, new legislation that affects the form. That is HB, or House Bill 391, which established a process for the early termination of a residential lease for certain service duty service member tenants who receive military orders to vacate civilian housing and move on to post-government or base quarters, basically. That law became effective, or will become effective, on November 1st, so on the same date that the biannual release of forms is to occur. And that's one of the major reasons why we made substantive revisions to the form. There were other sections that we revised as well. Section 2, the section relating to tenants, and Section 3, the one relating to the rental term, were revised to allow references to occupants, not just tenants. There was concern that landlords weren't getting the full information of who was actually living in the unit. They were only getting information about the people who were renting the unit. So you would have, for instance, a mother and a father sign a rental agreement because they're the ones paying the rent, but they would have, the landlord would have no idea of how many children they were bringing in. Well, I shouldn't say it that way, but you would have maybe a friend who's on the lease. They have 10 other friends who are going to be staying in the unit. The landlord doesn't really know about that because it's only the one friend that signs the lease. So now the new lease agreement has a provision, or at least a space, for the tenants to include information on all the occupants in the lease. The Section 3, as I mentioned, what the section related to the rental term was revised to include subcommittees' recommendations regarding prorated rent. Section 6 was revised, and that's the section on security deposits, to include recently acted legislation. And Section 9, the section on pets, that was significantly revised to provide space to define what is meant by a pet, include liquidated damage provision for tenants' unpermitted pets on the property. Liquidated damages provision is just a provision that says it's sort of impossible for us to say right now how much damage the pet's going to cause. So we're going to say that if you violate this agreement, it's going to cost you blank amount of money. So you could just write and say, you're not allowed pets. If you do bring a pet on, it's $100. That would be the liquidated damage provision. We also provided an option for the landlord to require a pet deposit. And we added one final provision in this section to confirm that the pet deposit does not relate to any service or support animal, because the law prohibits a landlord from receiving a deposit for someone who has service or support animal on the property. Section 13, the section on the addenda, was revised to include a reference to other addenda that may be incorporated into the agreement. And as I mentioned before, most of the major revisions to the form are due to that recently enacted HB 391 regarding military or service member tenants. Those revisions appear in the standard terms section H. You can find them there. Okay, hot topics. Permit me for just to take a swig of water here for a second. All right. This is a graph of the occurrence of issues on Legal Kokua since August 1st of this year. By far, the runaway hottest topic for the Legal Kokua line since August 1st has been, perhaps as no surprise to anyone here, the eviction moratorium. That includes terminating leases, raising rents, and evicting tenants. You can see here on the left, by the way, in order descending occurrence. If you include these first two categories here, which are really the categories that fall under the the eviction moratorium topic, it is responsible for well more than half of our calls. Next up are people calling about the purchase and sale agreement or the purchase contract. That is sort of an umbrella category. People who call on that topic rarely have questions about the form itself. They mostly have questions about the transaction that they are involved in. So we can't give legal advice at the Legal Kokua line, but we can give general guidance. And so that's what we do when somebody calls with a question particular to their proposed purchase contract in a transaction. There's a miscellaneous category that also is reasonably large. It's probably the only other one that's large enough to merit individual attention here. That, as you can see from the name, is basically a grab bag category. There are many different discrete questions that are posed on the Legal Kokua line that don't really relate to any major topic or category area, and that's what's included by that bar. And then the one on the far right, this is no joke, we've actually got 2 calls from a hypnotist provider asking questions about hypnotism. Well, I guess it is a joke to put it off there, but so that was just a weird situation. It actually happened twice. And they were calling from the East Coast for some reason. But anyway, so those are the major topic areas. I'll go into some of the bigger ones now and then offer it up for questions on any topic that you would like after. So the first major area here is terminating leases and evicting tenants. The moratorium, the eviction moratorium, has ended in the state, and the CDC moratorium was overruled by the Supreme Court. So there is no longer any eviction moratorium that prevent a tenant from raising a rent, a landlord from raising a rent or terminating a tenancy or evicting a tenant. There is, however, something called a COVID relief period, and was created by legislation passed in June, and that does restrict a landlord's ability to perform some of those tasks. And I'll describe how it restricts the landlord's ability here. A landlord for the next year can't evict a residential tenant unless they're behind on rent by a given amount on a certain date. And here are those amounts. As of right now, a landlord can't evict a residential tenant unless they're 3 or more months behind on rent. Again, that's because of this recently passed legislation. Soon, though, in about a week or so, about a month, landlords will be able to evict tenants if they're only 2 or more months behind, and it keeps cascading down. On January 6th, 1 or more month behind, January 6th of next year, August 7th of next year, it'll return to the way it was, which is that landlords can evict a tenant who is behind at all on rent. Okay. The recently enacted legislation also changed the notice provisions that's required to evict someone. First, and we've received many questions on this. The notice of eviction can't be given or served to a tenant who's not subject to eviction. So for instance, going back to the previous slide, if a landlord right now serves a notice of eviction on a tenant who is 2 months behind on rent, that notice would be ineffective. And that's because the tenant is protected by this COVID relief period. They would have to be more than 3 months behind. Okay. The second on the notice, the tenant must pay within 15 days. It used to be 5. It's now 15 days after receiving notice. And if they don't, then the lease is terminated. Okay. This is another big change. The notice has to contain very specific information. The legislation that requires it was actually quite detailed. Here's an overview of that information that it must contain. And if it doesn't contain this information, the notice is again ineffective. So I've grouped it into categories to hopefully make it a little bit easier to remember. First category is contact information. So the notice must contain the landlord's contact information, and if there's a property manager, the property manager's contact information as well. It also has to contain the tenant's contact information and a mediation center's contact information. I'll describe this in greater detail in a moment, but the law also requires the landlord to agree to mediation. So before serving a notice on the tenant, the landlord has to provide information on the mediation center. And in the category discussion here, the contact information. All right, the next major category is rent. The notice must contain a statement of how much, what the monthly rate is for rent. The tenant's going to know this, but you have to put in the notice anyway. You have to say how much rent is currently outstanding and due. And you have to tell the tenant in the notice what attempts you've made to get government assistance for the rent that the tenant hasn't paid, and that you have credited the tenant for all the government assistance that you've received. So that's the category of rent. The next category under the notice content is mediation center information, which I mentioned that we discussed in greater detail, and we will now. You have to express in the notice which mediation center is available to the tenant. You have to tell the tenant that the mediation center will provide their services to both the landlord and tenant without any cost or expense. You have to confirm, you have to explain to the tenant that the mediation center will contact them to schedule the mediation, and that the mediation center will confirm receipt of the landlord's request to do that to both the landlord and to the tenant. Then, and oops, I don't have a highlighted portion of this, but there is express language required now as well, which has to be in a certain kind of font, a certain size, and it has to be bold. That was too long to put in the presentation. It would just have taken up a whole screen, and no one would have been able to read it. But I can provide that information to anyone who requests it. So just call me, or if we are publishing this later, then I can include that information in the published version of this presentation. But it's about a paragraph, and it must be in the notice. That's it about the notice. Summary process. The time that you can file for summary process has changed as well. Now, you can only file for summary process if the tenant hasn't called to schedule the mediation, then you can file for summary process 15 days after serving the notice. If the tenant has called to schedule mediation, you can file the summary process 30 days after the tenant was served with notice of eviction. It's important to note that this is all about scheduling the mediation, not appearing at the mediation. So for instance, if the 30 days have passed since the notice went out, or put it this way, excuse me, if 15 days have passed since the notice went out and the tenant scheduled a mediation, but hadn't yet appeared because it was scheduled for 2 months out, then you would still have to wait the 30 days because it's not about attending the mediation, it's about simply scheduling it. So just want to make that clear. There have been some questions on that as well. Okay. And I think this is the last topic on this issue. Like the notice, the summary process complaint has to contain certain elements. And I've put a bulleted list of those elements here. It has to include the mediation verification statement, and that will be provided to you by the mediation center. It has to say expressly that you as landlord were willing to mediate the dispute and willing to schedule a mediation, obviously. And if the mediation was scheduled, you have to say when the mediation has been scheduled for, both date and time. All right, next topic, raising rent. For a long time, a landlord couldn't raise rent, basically since the eviction moratorium was in effect. And that's because when the eviction moratorium went into effect, it activated a particular statute called 127A-30. You'll see it here highlighted on the right. And that had prohibited raises in commodities and specifically defined it residential rent as a commodity. So while the eviction moratorium was in place, landlords were prohibited from raising rent. You're also prohibited from terminating a lease, obviously. That eviction moratorium is no longer in effect. And so there is no longer any prohibition against raising rent on a residential tenant. It's back to the way it was before the eviction moratoriums were issued, which is to say that you can declare rent you can just simply declare that the rent is higher and will be the new higher rent will be effective 45 days from the day that you just declare that it's higher. Or you can terminate the tenant's existing lease and enter into a new lease with that tenant or a different tenant at a higher rental rate. So in both cases, whether you're declaring that the rent is higher or if you're terminating the lease and then setting higher rent later, you have to give a 45-day notice to the tenant if the tenant's a month-to-month tenant. And that's the same as before. And that's really all there is in that subject. This is the last slide before the questions. The other hot topic areas, which I'll describe very quickly here, but I'm happy to describe in more detail if you want. I would say it would be designated agency, mandatory disclosures, and COVID screening. I'm going to start from the end and work my way up. COVID screening, there are quite a few questions about whether you can prohibit, whether a seller could prohibit showings to people who are not vaccinated, or if a seller can require proof that the person's vaccinated before they're allowed to attend a showing. And the answer to that is an undeniable yes, they can definitely do that. The reason for that is because all the health privacy laws do not apply to most people and entities. You have to be what's called a covered entity. And someone selling residential property, either as an owner or a broker, in no way meets the definition of a covered entity. So those privacy laws do not apply. And you can most certainly deny showings to people if they're not vaccinated against the virus, and you can most certainly ask for proof of their vaccinated status. Regarding the disclosures, there've been a bunch of kind of miscellaneous questions about disclosures, so I thought it might be helpful here to just to remind everyone what the rule is. There are there is a list of things you specifically have to disclose, and you can look to our form on a seller's required disclosures for that list. But anything not on that list that has to be disclosed to the buyer is anything that would materially affect the value of the property. So if you knew the floor on the second floor was about to collapse, you would have to tell the buyer that. There is some question about whether you have to make these disclosures to things that are kind of transitory, not an immutable quality of the property. For instance, I got a call 2 days ago about whether a seller would have to disclose the existence of a temporary homeless encampment across the street from the home that's to be sold. And after some research, I confirmed my instinct, which is no, they would not have to do that. But the rule, which to keep in mind, is it's almost like a do unto others type rule. If you were the buyer, would you find this information important? Would it materially impact your decision in purchasing the property? Which is to say, would you pay more or less based on this information? And finally, the designated agency category. This is a huge topic, which we don't have the time to discuss here, but I'm happy to just answer any questions you may have either here or over the phone. Quickly though, it's a new form coming out. There is nothing in our laws that prohibit designated agency, nor is there anything in our laws that allow it. So the form is going out for people to use, but we urge caution. And I think you should speak to your attorney for your brokerage before practicing it, because it is a complicated area and there are places where liability can exist. It is also a useful tool though. So if you're interested, you should definitely look into it because it could help your practice. And with that, I'll open it up to questions.
Hey, Jason, we have a question. It's two parts. So the first one is, can a condominium board of directors specify that a comfort animal can only be a cat?
Yes. Believe it or not, the rules only protect dogs. It has to be a dog. Yeah. So you, if someone wants to bring a service animal onto the property and it's not a dog, you can prohibit that.
Okay, so I'm pretty sure this answers the second part of that question. It says, further, if the applicant wants to have a comfort animal other than a cat, can the BOD deny the request?
If it meets the definition of a service animal and it's a dog, then no, they can't deny yes, they can still actually deny the request because their responsibility is just to make a reasonable accommodation for the person. So if for whatever reason, it's not reasonable to allow the service animal in the unit, then you could still deny it. But you're treading on some landmines there. If it's a true service animal and it's a dog, you would really have to be quite sure that it's completely not reasonable to allow the animal on the property. Otherwise, you're going to get dinged.
Okay, so there was a clarification. It says, the question refers to a comfort animal, not an assistance animal.
Okay. I would ask what the definition of comfort animal is. I don't know of any statutory definition of comfort animal, which is to say that I don't know of any protection for a comfort animal in the law. So
okay,
it wouldn't be protected. Yeah.
Okay, the next one, I guess, is in regards to terminating leases and evictions. If there is a property manager who is considered the landlord for purposes of provided contact information.
Oh, right. So you have to provide both the contact information for both. If there is a property manager, you have to provide the contact information for the property manager and the landlord.
Okay, next question is regarding the purchase contract. If material items about the property are discovered during the J1, period, does the A4 or the additional disclosure provision and timeframe still apply?
Timeframes to apply. So if you just, I think I understand where the questions are going, but if I don't, please let me know. So if you discover something that would materially affect the property that wasn't contained in the initial disclosure because you frankly didn't know about it at that time, then you must disclose it. Once it is disclosed, I believe the buyer has 10 days to cancel the contract if they want. Don't quote me on that number. I think it's 10 days. But I'll go back and check for you if you want. And
Okay.
Yeah, go ahead.
No, I was gonna say, I'll let you know after this who that was so you can reach out to them.
Sure.
Okay, and then the last question I have right now is, I am unfamiliar with the term designated agency.
Yeah.
Would you please give us a formal definition of the term? Thank you.
Yeah. I'm going to start with defining dual agency just because it helps to understand designated agency. So dual agency is when one broker or one brokerage represents both the buyer and the seller in a particular transaction. Under a dual agency situation, you can't advocate for either the buyer or the seller, although you represent both. And the reason why you can't advocate for both is because you represent both and you can't advocate for one without sacrificing the interest of the other, right? Because the buyer is always going to want to pay less and the seller's always want to get more. So you can't advocate for buying for less because that would breach your duty of loyalty to represent the seller, which is why in a dual agency situation, you are more of like a facilitator. You just bring them to the table, make sure the deal gets done, tell them how homes are sold here in Hawaii, and that's it. Designated agency allows you to advocate for one side. And the way that you can do that, and the reason why you can do that under a designated agency, but not a dual agency, is because in a designated agency, you have, again, one brokerage representing both the buyer and the seller. But in the case of a designated agency, that brokerage, as the term implies, designates one of its licensees to represent the buyer and a different licensee to represent the seller. The licensees on each side can then advocate for their client. So the one that you designate to represent the buyer can advocate for a lower price for the home, while the one that you designated for the seller can advocate for a higher price. And there's no breach of any duty in doing that because each one of those designated licensees exclusively represent one side of the transaction. Hopefully that helps explain it.
Okay, I have more questions.
Fire away.
If there is a property manager, who is considered the landlord since the property manager is acting on behalf of the owner?
I'm sorry, say that again. What?
If there is a property manager, who is considered the landlord since the property manager is acting on behalf of the owner?
Oh. That depends on the contract itself, because the contract will usually define who the landlord is. I think in most cases, the landlord is defined as the actual owner, and the broker will sign the agreement on behalf of the owner, as will just sign the agreement on behalf of the landlord, which is the owner. Hopefully that answers it.
Okay, next one's a little long, so
yeah,
bear with me. It says purchase contract A2C states that dual agency representation requires a separate dual agency consent addendum. Doesn't this addendum no longer exist? Must any applicable dual agency disclosure and consent and/or designated agency disclosure and agreement form therefore be attached to the purchase contract as addenda?
So the first part of that question, the dual agency form still exists because dual agency still exists. So we need to keep that form there. Designated agency, that's a new form which we're releasing in November. So after November 1st or on November 1st, there will be an option for you to practice dual agency. And if you do select that, there would be, you would select the dual agency form and an option for you to practice designated agency. And if you select that, you would then use the designated agency form. You would never use them both at the same time, but both would exist so that you could choose among them if you wanted to practice either. Regarding when the form needs to be signed, the law says that a dual agency can't exist unless all the principals involved consent to it in writing in advance. So, for instance, you can't begin acting as somebody's designated agent unless you've explained what that is to the buyer and the seller, and both the buyer and seller agree that they're okay with you serving as a designated agent and have signed that disclosure and consent form saying that they're okay with it.
Okay, one more is, I understand in the mainland, some states specifically allow designated agency. Is the state of Hawaii working to allow it within the law?
I know no active efforts to allow it right now. I know it's hotly debated though. There is an advantage to having an express provision allowing it in a law, and a disadvantage to having an express provision allowing it in the law. I'll quickly discuss each. The advantage of having it in the law is it makes your duties as a designated agent clearer in almost all instances. I actually reviewed the statutes and regulations in each state that allows it and found that in almost all cases, if the state allows it, they also describe very specific things that the agent has to do. And as a reward for doing all those things, the state provides a safe harbor for the agent. So for instance, it's never this simple, but just for our purposes, the state will say, you can be a designated agent. We're expressly saying that's okay, but you first got to get the consent of one of the parties, of both of the parties before doing it. It's got to be in writing. And if you do that, then you can't be sued just for the mere fact that you're a designated agent. So it would create a safe harbor. So the advantage is you know more what your responsibilities are, what's expected of you, and there is express statutory protection for you. So that would be the advantage. The disadvantage is the more regulations and law on an issue, the more constrained you are to act. So it's sort of freedom versus safety. And right now we're in the freedom side of the camp. But I know there are talks going on about having perhaps the law changed to expressly allow for it and put us in the other camp.
Okay, one more is, there was a prior designated agency form that seemed to indicate that the broker would remain neutral, but the two agents could advocate. Does that nuance exist, or would the two brokers and a designated agency absolutely have to have a firewall between the two sides?
Okay, I think that's a two-parter. The first part is—
it sounds like it, yeah.
Yeah, so the first part is there still a prohibition against advocating for one side or both sides of the transaction if you're serving as a dual agent? And the answer to that is yes. And the reason for that is because as a dual agent, you're representing both sides the same. And
he said not dual designated.
Oh, I'm sorry. Okay, well then, the designated agent, the agent itself, so the licensee, we're not talking about the brokers, the licensee who's been designated to exclusively represent one side of the transaction can advocate for their client's interest, even if it comes at the cost of the other side of the transaction. So this agent that's been assigned to exclusively represent the buyer can say the price should be lower. And by the same token, the one that's been assigned to exclusively represent the seller can advocate for the seller, even if that comes at the cost of the buyer. So for instance, this designated agent for the seller can say the price of the home should be higher. We're only going to sell it if it's higher, and that kind of thing. I know there was a second part of the question too, but it's left my mind. Did I answer the full? Yeah.
Yeah, the second part was, does that nuance exist, or would the two brokers and a designation agency absolutely have to have a firewall between the two sides?
Firewall. You might remember I said that when I was preparing these webinars for the designated agency, I read all the statutes and regulations of states that expressly allow for it. More than a handful of those states require in writing, they just put it plain as day, black and white in their regulations. If you're practicing designated agency, you have to create a firewall, and the firewall has to do A, B, C, and D. Many of the states that expressly allow designated agency don't address the firewall at all. So this is all by way of saying you might be able to get away without the firewall, but I don't see how you could, because the firewall is meant to protect confidential information that you learn from this client that you represent exclusively, right? So in a dual agency situation, not designated, but dual, where you represent both sides, there's no need for the firewall because you're representing both of them. Everyone knows that you have all the information. You're not advocating for either side, you're just facilitating. So people are giving you the information and you're using that to help make the deal. In a designated agency, people will give you confidential information, expecting you to advocate for them and to use that information for that purpose. So you have to have a way to make sure that that information doesn't leak to the other side. Otherwise, you're breaching your duty to your client. So in a designated agency relationship, you do need a firewall. And in a dual one, you don't.
He said, is the firewall just between both agents, or both agents and both brokers?
Both brokers. Oh, brokerage houses, maybe. Yeah. So I think I understand where the question is going. That is a thorny question. Different states deal with this in different ways, but I'll at least explain the problem. So the problem is, in our state, like in all other states, you can't have a licensee just operating in kind of a rogue fashion. They need management and supervision. The regulations in the law is pretty specific. A principal broker or an appropriate broker in charge has to manage each licensee. So that creates a problem with the firewall, though, right? Because how do you manage somebody without having information? So the solution that I recommended during an early webinar is to assign one broker in charge to perform the management and supervision duties for the designated agent on one side of the transaction, and a different broker in charge to manage and supervise the designated agent on the other side of that transaction. That scheme would allow, scheme's a bad word, but that framework would allow the designated agent to protect the confidential information, and it would also make sure that the brokerage fulfills its responsibility to manage and supervise each of the agents. Now, I don't want to say that's the only way of doing it, and because there's nothing that says that there is, but it's just one solution that I thought of that I think would make sure that the designated agent and the brokerage house are fulfilling their statutory and regulatory responsibilities.
Okay, so I'm kind of going out of order because this still kind of pertains to this. The question is, how can designated agency actually work in Hawaii, since the principal broker is ultimately responsible for the representation of the client? Even if you have two different BICs, the ultimate responsibility goes to the PB, and there is only one PB.
Right. we're not the only state that sets up the law like that. In fact, every other state does the same. And there are some states that expressly allow for designated agency. They come up with their own scheme works to allow for it. And some of them create specific frameworks to address that issue specifically. I'm afraid that I know that I've read them. There were at least 3 or 4 of them. And I'm afraid I can't remember them, but I think it's basically this, that they require the brokerage to appoint basically what we would call a broker in charge to manage and supervise each agent. And that satisfies those states, and we think our state's requirements for management and supervision, because the broker in charge is supposed to, although the principal broker is ultimately responsible for what happens under their brokerage house, the principal broker is also not supposed to appoint a broker in charge who is not capable of managing or supervising the agents.
Okay. Okay, so this one is actually going back, and I think it's more of a clarification. It says, this was the landlord and things. It says, if there is a PM, the PM executes the rental agreement as the landlord. The owner does not get involved and is generally not identified separately on the rental agreement. The use of the terminology landlord instead of owner is confusing.
Yeah. That could be a bit of a dangerous situation, because that seems to be, it sounds like they're describing an undisclosed principle. That is which is a legal term abroad. It basically means, well, I'll explain the policy behind it first, because I think that'll help. So if you're going to contract with somebody, if you're going to make a deal with somebody, the law says you have the right to know who you're making a deal with, because a lot of the decisions you make about that deal have to do with the person you're dealing with. So if somebody represents another but doesn't mention that when the contract was signed, then let's use a concrete term. So sorry, I'm trying to come up with, there's a case back in the mid 80s here in Hawaii, where it went all the way up to the Supreme Court. It's called, it's a property house case. And that was another case involving an undisclosed principle. Anyway, the result of that case was, because the buyer didn't know who the seller actually was, they would, I'm sorry, I'm kind of fumbling this in. Does the person just want a clarification on the form as to what you mean by landlord?
They actually added 2 more things. It said, not an undisclosed principle, custom and practice. And then it said, current rental agreement form does not provide for identification of the owner when a property manager is executing the documents.
Okay. Well, I guess I'll have to defer. If you could take down that person's name, I'll look at the form again. I can't obviously do it now because the webinar is going, but I'll look at how the terms used in the form. I'll compare it against the regulations and statutes, and then I'll give them a definite answer. Okay, so it came in anonymous. So whoever the anonymous person is, you're welcome to give the office a call at 733-7060, and then you can have a conversation with Jason. Yeah, and I'll look into it in the meantime. Okay, and then one more is the designated agency form that will be published in November available now? No, it's not, but it will be, as the questioner implied by the question, available November 1st. Okay, that looks like that was it.
Thank you, Wendy. That was awesome. Thank you, Jason, for your time. I know that there's a lot of questions, a lot more questions to be asked, and just want to let everybody know there is a let's see, and it's coming out in your Realtor, HAR Realtor news bulletin today. So don't forget to take a look at that Hawaii Realtors email. And we're going to be holding a Legal Kokua live webinar designated agency forum on October 20th. And that's going to be at 10 to 11 a.m. The registration link will be in your email, so keep an eye out for that. And thank you so much, Jason, for your time. And thank you to our REBI members and our guests. That's all we have for today. So have a wonderful weekend and stay safe. Aloha.